Washtenaw County Trial Court is now in session. The Honorable Patrick Conlin Jr. presiding.
Good afternoon.
People versus Derek Smith, 21105 FC.
Jessica Blanche, appearing on behalf of people.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Smith. Mr. Smith, could you please state your name for the court?
Mr. Smith, can you hear us?
Yes.
You're okay. All right. Okay. Mr. Smith, I'm going to have you raise your right hand to be sworn in.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Sir, you can put your hand down. You've had an opportunity to consult with Mr. Bernstein before coming to court today about what's going on today?
Yes.
Okay. Is it your intention to resolve this case through a plea agreement?
Yes.
And the plea agreement includes that you'll be pleading no contest to 2 crimes. Is that correct?
Yeah, I just want to know what the 2 crimes are before I, yes, but.
Judge, do you want me to put the plea agreement on the record?
I do. I mean, I think I have it, but yes, go ahead.
Judge, we're dismissing count 2, which was assault GBH. He's pleading to count 1, which is assault with intent to murder. Count 3 is a felonious assault. I'm offering a sentence agreement to 11.5 to 25 years MDOC. His guidelines are 22 to 37.5 years. I'm dismissing the habitual offender notice.
Okay. So you'll be pleading no contest then to counts 1 and 3, which are assault with intent to murder, and 3 is felonious assault.
Yeah.
Is that what your understanding is?
Yes.
Okay, you understand that you're pleading no contest, which means you're not admitting that you are that you did what is alleged, but you're not contesting it either. Right. And so that means that I'm going to treat this like a guilty plea. You understand that, correct?
Yes.
Okay, you just heard the prosecutor put the agreement on the record. Did you understand that? And do you want to proceed today with that?
Yes, sir.
Okay, so the plea agreement and the sentence agreement are between you and your lawyer and the prosecutor. They don't have anything to do with me. And so what that means is that if you do everything according to what we plan on, then I'm going to sentence you according to the sentence agreement, and I'm going to go ahead with the plea agreement. But if you do something between now and the date of sentencing that causes me to change my mind, like you get another case or you do something else, or if I read something so surprising or shocking, excuse me, in your pre-sentence report, I may back out of this. And if I do, your lawyer is going to have to ask me to allow you to withdraw your plea. It's not a guarantee. That's not the normal situation, but you just need to know that's a possibility. Do you understand that?
Yes.
Okay. Are you currently on probation or parole? Because the no contest plea could affect that.
Parole.
Okay. So you've had time to talk this through with your lawyer, maybe even your parole agent, and you understand that this could affect that, but you want to go ahead. Is that correct?
I haven't had a chance to talk to my parole officer or my attorney about this. Affected in what kind of way, Your Honor? What kind of way?
I don't know. I don't know what the terms of your parole are, but obviously a plea of guilty might impact whatever your parole status is.
Derek, he's saying that everyone needs to be warned that if people are on probation or parole, any sort of plea could affect probation or parole. I mean, I think that's pretty obvious, right?
When he said I had a chance to talk to my parole officer, I haven't. This was just sprung up on me today. I haven't had a chance to talk to my family, nobody, my fiance, nobody. So I'm just like, come on, let's go, let's get it. Come on.
So, okay, Mr. Smith, but I'm going to ask you a series of other questions that are like, are you being forced into this? Are people trying to encourage this? Are you being promised things? The problem is, sir, is that if you're going to plead, you're going to plead. If you're not going to plead, then we're going to try the case on Monday. It's okay. You have that right, but we can't act like this is under duress, like you don't have a choice in this. If you don't feel you have a choice, we can't go ahead with the plea. So it's kind of your call.
Are you gonna be on the bench tomorrow, sir? I can't have overnight to think about this to tomorrow overnight. And I have a guaranteed answer for you in the morning. That way I can try to contact my parole officer or anything.
Derek, I
Well,
have court in the morning in Lenawee. I can't guarantee that I'll be able to jump on in court tomorrow morning.
So the short answer is, Mr. Smith, I will be here tomorrow, but your lawyer may not be available. I don't know if the prosecutor is available. I assume that someone in probation is available if it's not Agent Benetti. But I mean, we can potentially do that, but
Okay,
you know,
stop.
I don't know. I can't.
Don't mean to stop you, Your Honor. With all due respect, excuse me, this is my life. With all due respect, Sam, I'm asking you to take 20 minutes out your day tomorrow and give me till in the morning so I can just talk to people and we take this in the morning. Please, Sam.
Your Honor, could I
Well,
have a breakout room to talk to Mr. Smith for a moment?
Let me just see if I can solve this. Let's start with maybe some low-hanging fruit. Ms. Blanche, are you available either tomorrow morning or at like 1 o'clock tomorrow afternoon?
Yeah, I can be available.
All right. So, Mr. Bernstein, if you're in Lenawee in the morning, would you be available at 1 o'clock tomorrow afternoon?
I could make myself available.
I mean, again, I'm just trying to offer kind of, you could meet with Mr. Smith right now. You can have a breakout room, talk him through whatever he needs to. But if we go tomorrow, Mr. Smith, it's going to be the same deal. The questions are the same.
I
So
understand.
it's basically like, are you doing this of your own free will? So,
Yes, I understand that. I just need time to talk to a couple people. That's it. I understand that. I'm not saying I don't want to take it. You know, I just haven't time to talk to anybody in my family.
Can we break out for a moment, please, Your Honor?
sure. I'll be right back. I'm not going, so we're not ending the hearing right now. I'll be right back. All right.
We're back on record.
Okay. What are we doing, Mr. Bernstein?
Your Honor, Mr. Smith needs to talk to his family. He doesn't feel comfortable without talking to his family. Could we do this just first thing in the morning tomorrow? I can Zoom from my car. I think, but we need to know what's going to happen. I think sooner than later. Would it be possible to do it in the morning?
Yeah. Ms. Blanche, are you available in the morning?
I am, Judge.
So, I mean, I have a docket that starts at 9. So why don't we say we'll do this?
Doing VOPs too.
Oh, well, perfect. But so why don't we say we'll try to do this at like 8:30, 8:40, something like that. I have VOPs tomorrow too. So if there are other people in custody, I'll be doing those right around 9. So we can start with Mr. Smith and I'll just continue on with the docket. Okay.
So 8:30, Judge, would the jail be able to accommodate us at 8:30?
Well, that's a good question, Ms. Blanche. I'm
Okay, yes.
optimistically saying 8:30, but I mean, it'll probably be, let's say 8:45. I mean, hopefully we can get them to.
The officer here just
We
said
can
yes.
start with Mr. Smith. I mean, I've got in custody violators tomorrow morning anyway, so that would be at 9. So we'll just start with Mr. Smith. Let's try to do it a little bit before 9 o'clock.
Okay.
Thank
All
you,
right.
Your Honor.
Okay, that's fine.
Appreciate
So
it.
we'll see you all back here tomorrow morning.
No, thank you.
Thank you, Judge.
Thank you, Your Honor. Thank you, Ms.
All right.
Blanche.
Washtenaw County Trial Court is now in session. The Honorable Patrick Conlin Jr. presiding.
Good
People
morning.
versus Judge. People versus Derek Smith, 21-105 FC.
Jessica Blanche appearing on behalf of people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Smith. Mr. Smith, could you please state your name for the court?
Derek Smith?
All right. You can hear us, Mr. Smith?
Yes, sir.
Okay. Today's date and time set, I believe, for an entry of a plea.
Yes.
We did break yesterday and give you some time to reach out to people. And are we ready to proceed?
Yes, Your Honor. With all due respect, I thank you for allowing me the time to do so, and I'm ready to take
Nope.
the plea.
No problem, sir. This is very important and you need the time. Okay.
Yeah, thank
So, sir, I'm going to have you raise your right hand to be sworn in.
you. Yeah.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. And you are Derek Smith. You can put your hand out.
Yes, sir.
All right. And you've had an opportunity to speak with Mr. Bernstein completely enough to understand what's going on and you want to proceed today. Is that correct?
Yes, sir.
All right. I'm going to state for the record what the plea agreement, what I understand it to be, and I'll ask the lawyers to correct me if I don't get it exactly correctly, because we need to have it on the record exactly correctly. And then we'll go ahead with some questions. Okay?
Yes, sir.
My understanding is that, Mr. Smith, you will be pleading no contest to counts 1 and 3, which is 1 is assault with intent to murder, and 3 is assault, felonious assault with a dangerous weapon. And that at sentencing, count 2, which is assault with intent to create bodily harm less than murder, and the habitual fourth offender notice will be dismissed. And that's the plea agreement. And then the sentence agreement, as I understand it, is that you would serve between 11.5 to 25 years in MDOC. Ms. Blanche put on the record the guidelines yesterday are 22 to 37 and a half years. So that's my understanding of the plea agreement and the sentence agreement. Is that everyone else's understanding?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right. So now, series of those questions that we started with yesterday, Mr. Smith, and this is sort of like goes to, is this of your own free will and that sort of thing. So did you hear the plea agreement, the sentence agreement? Do you understand it and do you want to proceed today?
Yes, sir.
Okay. The plea agreement and the sentence agreement are between you and your lawyer and the prosecutor. I'm only giving you notice of this. I'm not telling you this is going to happen. But it is possible that if I look at your pre-sentence report or you get into trouble between now and the date of your sentencing, I could choose to not support the plea agreement and the sentence agreement, and you would have already pled guilty. I'm not saying that you're going to do that, but if that were to happen, Mr. Bernstein would have to ask me through a motion to allow you to withdraw your plea, and I can't guarantee you that that will happen.
I'm sorry, just I think it's a no contest, please. Isn't that correct, Mr. Smith and Mr. Bernstein?
It is. Sorry,
Okay.
yes.
Right.
So you would have pled no contest to a crime, and you may not be able to withdraw that plea. I'm not saying that will happen, but you just need to know that that's a possibility. Do you understand that?
That's scary, but yeah, I mean, because I thought it seals the deal, but I'm just, I mean,
it's a similar to these other questions, Mr. Smith. Like these are all things that you have to have notice of. But I'm just telling you that, if you don't do anything wrong between now and the date of your sentencing, and if your pre-sentence report is not so shocking to me, I go along with these all the time. So it's not like I'm telling you particularly, Derek Smith, should be careful of this. I make this announcement every time because it is possible. You just need to know that. Okay?
Yeah.
Okay. Are you currently on probation or parole? Because this no contest plea could affect that.
Can it affect it in what kind of way, sir? I'm trying to do the time I take it 11 and a half years to 25. I'm trying to do that. It took a long time to come up with that. It's just so much going on.
Right. But this is where we got tripped up yesterday. So if you'll remember, the question is whether you're on parole, and you just need to know that by pleading no contest to a crime, that could affect your parole. I'm not change the way I'm looking at your sentence, but I'm just telling you, you have the ability. You should know that that's a possibility. Do you understand?
Yeah. Okay. Yes.
Okay. All right. Other than what's been stated in court, has anyone promised you anything to get you to plead no contest?
No.
Has anyone threatened you in any way to get you to plead no contest?
No.
And is the decision to plead no contest yours to make? I mean, all things considered, are you acting on your own free will right now?
Your Honor, can I ask a question?
Sure.
Please. And I'm not trying to hold up no more time. I appreciate everything you did, but I just need to ask a question. And
Go ahead.
We halfway through this. It's just a lot to try to take in right now.
Go ahead. You're fine. Ask the question.
With the evidence that was missing, if I request that you put in extra jury instructions to allow the jury to hear about the evidence that's missing, is that possible to happen? I mean, that you can do that?
So here's where I can't advise you. You have a lawyer, and I can't give you legal advice. So you've had an opportunity to speak with Mr. Bernstein. So if you want to proceed trial, we can do that.
He just,
But I can't give you advice right now.
he just left right off the screen. I don't know what's going on. He's
He's
supposed
right there. I
Okay.
can see it.
I can't see him. I can't see him. So,
I'm right here, Derek. I'm listening to everything that's being said right now.
okay. I just wanted to it just seemed like I'm just, all this extra time stuff is just spooking me out, man. I didn't.
The judge just has to go through this dialogue, and part of that dialogue is putting people on notice of certain things that could happen, and that's all. It's not to scare anyone. It's just to make sure people are aware. I mean, this is stuff that we've discussed in the past about what can happen. I think based on the notice regarding like parole, we can be comfortable moving forward.
Yeah, I figured out about parole. I mean, I'm okay with that part, okay? Because this is, I think this is going to supersede I only had 14 months left on parole. So I was just worried about the other things that was said. Let's go ahead and get this over with. Praise God. Come on.
Okay, so the last question I asked you is this decision to plead no contest yours to make? Are you okay making this decision?
Yes, come on.
Okay. All right, so I'm going to read through the maximum penalties on the two charges that you're pleading no contest to. I don't want you to freak out about that. You have to have notice of what the maximum is. You have a sentence agreement to what you're going to be sentenced to, but I just have to put this on the record. So I don't want you to be, I don't want you to be alarmed by that. Okay.
Yes, sir.
All right. So you are pleading no contest to assault with intent to murder, which is a felony, which could be a term of life or any number of years. There would be DNA taken upon arrest, and a consecutive sentence could be imposed if your assault was committed in a place of confinement. So that's the maximum penalty on that. The count 3 is assault with a dangerous weapon, or what we call felonious assault. That's a felony punishable by up to 4 years incarceration and or a $2,000 fine. Again, DNA is taken upon arrest, and a consecutive sentence could be imposed if that assault was committed in a place of confinement. So those are the maximum penalties on those two charges. So do you understand that those are the maximums?
Yes.
Okay. Sir, your plea of guilty your plea of no contest will cause you to waive your trial. And at trial, you'd have certain rights. I'm going to go over some of those rights with you, okay?
Yes.
At a trial, you'd have the right to be tried by a jury. You'd have the right to be presumed innocent until proven guilty. And you'd have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. At a trial, you'd be able to have witnesses testifying against you appear in person. You'd be able to question those witnesses. And if you needed witnesses for your defense, I would order their appearance by subpoena. Finally, you'd have the right to remain silent, meaning you could choose to not testify, and that silence would not be used against you. Also, if you wanted to, you could testify at the trial. So those are some rights that you are giving up. So I need to ask you, do you understand each of those rights, and that by pleading today, you'll give them up?
Yes.
All right, I've got 6 technical questions for you. So bear with me.
Oh, Lord.
You understand that if I accept your plea today, you can't come back on another day and tell me that your plea was the result of threats or promises that you're not telling me about right now. In other words, if someone's threatened you or promised you something off the record, you need to tell me today, because you won't be able to come back later and claim that. You understand?
Yes, sir.
All right. And similarly, if I accept your plea, you can't come back later and tell me that it wasn't your choice to do this today. Do you understand that?
Yes, sir.
Okay. 2 appeals questions. Because you're pleading, you're going to give up your trial, which means you give up your automatic appeal. Let me explain that. If you had the trial and didn't like what happened, you could automatically go to the Court of Appeals. By pleading today, it doesn't mean that you can't go to the Court of Appeals. It just means that you have to ask the Court of Appeals for permission to take the case or hear the case. And the Court of Appeals decides that. I don't decide that. So what you're giving up by giving up the trial is the automatic appeal. You understand that?
Yes, sir.
Okay. And finally, because you're not going to have the trial, you could have potentially had issues arise during the trial that you could have appealed, but because you're not going to have it, you're giving
There's issues already with the missing evidence. I mean, I'm trying to get this. There's issues already. You know what I mean?
So you understand, though, that by giving up the trial, you're not going to be able to make it claim about those issues, right?
Yes, sir.
Okay. 2 last technical questions. I don't know if you're a U.S. citizen, but if you're not, a plea of no contest could cause the federal government to seek to deport you. I would have no say in that, but I just need you to know that's possible. Do you understand that?
Yes.
And likewise, certain crimes have reporting requirements on the sex offender registry. This may or may not impact you at all, but you just need to know it's possible. Do you understand that?
Yes, sir.
All right. As it relates to assault with intent to murder and felonious assault, how do you plead?
No contest.
Okay. I did go through the preliminary exam transcript. I find that there's enough factual basis contained in the testimony given in the preliminary exam transcript to support the plea no contest. I'm going to ask the lawyers to concur or, make an argument there if it's not. Okay.
Judge, I would agree.
Agreed, Your Honor.
Okay. So I do find that the elements of the offenses found in counts 1 and 3 of the information that was dated March 1st, 2021 are fully covered with the information and the testimony presented in the preliminary exam transcript. Counsel, let me ask, are either of you aware of any promises, threats, or inducements other than those disclosed on the record?
No, Your Honor.
No, Your Honor.
Has the court complied with MCR 6.302?
Yes, Your Honor.
Yes, Your Honor.
All right. The court finds the defendant's plea of no contest is knowingly, understandingly, voluntarily, and accurately made. The court is also satisfied that there is a factual basis to support the finding that you are responsible of the offenses of assault with intent to murder and felonious assault as contained in the information dated March 1st, 2021, and I will accept your plea of no contest. Prior to sentencing, sir, you're going to have to give a pre-sentence interview. Probation will contact you at the jail to set that up, and they will schedule that interview. Mr. Bernstein, do you wish to be present during that interview?
Yes, Your Honor.
All right, so I'm going to leave it to you to coordinate with Agent Seibert or probation department, as well as Mr. Smith, to make sure you're available for that, okay?
Yes, Your Honor.
Is there a sentencing date?
Hold that. We're going to tell you right now.
Okay.
Sentencing in this matter will be?
December 14th at 1:30.
All right, December 14th at 1:30 p.m. Mr. Smith, do you have any other questions before we sign off?
No, sir.
Okay. Appreciate your desire, your need to talk to people. It's a big deal. So I'm glad we were able to give you that time.
Yeah,
So
I appreciate
that will conclude the hearing, and the trial for Monday is now canceled.
Yes,
Okay.
Thank you, Your Honor. Thank you, Ms.
Thank you.
Blanche.
Number 47 and 48, People versus Derek Smith, 21105 FC.
Jessica Blanche, appearing on behalf of people.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Smith. Mr. Smith, can you please state your name for the record?
Derek Smith.
Mr. Smith, you can hear us?
Yes, sir.
Okay. Well, this is kind of a mess. So we've got a couple things. It was supposed to be a sentencing today. Mr. Smith has filed a motion for a million things: relief from judgment, withdraw his plea, motion for a Ginther hearing, discharge attorney for good cause, evidentiary hearing, and then Mr. Bernstein, maybe predictably after that, filed a motion to withdraw as counsel. So, I have thoughts about this, but I think we have to do things in a proper order. So my first question is, Ms. Blanche, did you get any of this? It isn't clear that it was filed in Odyssey and that you have copies of it.
I received, Mr. Bernstein emailed me his motion withdraw and attached Mr. Smith's motion. Since Mr. Smith wasn't in pro per yet and Mr. Bernstein was still representing him, I couldn't really answer his motion and send him a response because it wouldn't be appropriate for me to contact him. So I was waiting on the court to either appoint him counsel or keep Mr. Bernstein on the case. I obviously have no objection to him withdrawing. And then, so I'd ask you to adjourn Mr. Smith's motion for next week or whenever the court's in session again, so that I have an opportunity to respond to him directly or to his newly appointed counsel.
So, Mr. Smith, you would like me to allow Mr. Bernstein to withdraw as your attorney, correct?
Yes, sir.
Mr. Bernstein, you would like to withdraw as his attorney, correct?
Yes, Your Honor.
Okay, well, let's go with the low hanging fruit here. I will grant the motion for you to withdraw and we will appoint counsel for you, Mr. Smith. What I can do then is basically on all of your asks, all of your motions, I'm going to adjourn them to January 25th at 1:30. That is going to be in person for your new lawyer, and for Ms. Blanche, you will not be transported, so you'll be here on Zoom. And then after we hold that thought, after we've dispensed with or figure out what's happening with all of your motions, then we will set either another date for whatever. If I suppose if I grant them or grant the main part of them, I would potentially set a new date for a pretrial. I'm not guaranteeing you in any way that I'm going to grant them, but I'm also saying that if I don't grant them, then we'll be looking at a new sentencing date. Okay?
Yes, sir. So you said it'll be in person? The next one will be in person?
So the deal is this. I'm going back to in-person court in January, except for the transport of in-custody people, defendants, from the Washtenaw County Jail or Michigan Department of Corrections. If you wish to be seen in person, I believe you have that right to do so, and that's kind of up to you. But you would normally, if you're in custody, you're going to appear via Zoom just like you are today. Okay?
Yes, sir. I have one question, sir, before we end.
Sure.
My guidelines was, I was told that they were starting off at like 20, I think it was like 22 years, and I got like 11 and a half out of the 22, but on the PSI report, he counted it as 171 months to 285 months, which put the minimum at 14.25 years and the max at 23.75 years. So it's not, I'm just saying it's a discrepancy there, because I was told it was at 22 years to start with. When I see the lower end here, in the PSI report is at 171 months, which is 14.25 on the minimum.
So I really probably can't discuss any of this with you until you have a new lawyer. Okay. I mean, number one, your lawyer can look into it. Number two, if that doesn't, if you don't get the information you need, you're welcome to ask that question again, but I can't really just start throwing out my thoughts or analysis on your pre-sentence report. And so I guess what I'm doing today is I'm granting the relief you requested. Once you get your new lawyer appointed, I'm happy to consider discussing this, okay?
Okay, so then, so the next time I'll see you, it'll be in front of you for the motions on what, January 25th?
Correct. So Ms. Blanche will have an opportunity to respond to your motions. We will have that hearing on January 25th. If I deny your motions, I will set the date for sentencing. If I grant your motions, then I will set a date for a Ginther hearing or a pretrial or whatever. That's kind of the next order of events. Okay.
Thank you, sir. You have a great day.
Wait, Judge, you're appointing him new counsel though, correct?
Yes.
Okay, so his in pro per motions, do you want me to respond? I mean, I don't know if I should respond to those or just wait for his new appointed counsel to re-precipitate a motion, because obviously they're going to want to put case law in with his motion. So are you going to have the new counsel I'm assuming you're going to have new counsel re-precipitate it for the 25th, or if we want to put a date, maybe we should put it on January 5th so he knows who his new counsel is, and then they can file the appropriate motion so that it can be heard by the 25th.
That's probably a good idea. What's it, the 5th or the 4th?
It's the 4th.
All right. So why don't we actually set this for January 4th? And then you'll have new counsel appointed. And Ms. Blanche is correct, Mr. Smith. If you have a new lawyer, you're going to want that lawyer to lawyer up your briefs a little bit. And so at least then they'll have notice of it. And so we'll then schedule the next date once we have that.
Okay, so I can discuss those guidelines issues with the new attorney as well, right?
Well, I mean, you'll have the opportunity to totally participate. What I'm not going to do now, I mean, I usually take comments from the parties, but I'm not going to have your lawyer argue and then have you argue separately. So that's something that we can talk about on January 4th, because I'm not deciding those motions on that day. All we're going to do is have a brief hearing to sort of let your lawyer know the timing and the next dates, okay?
Yeah, I'm just saying it, Your Honor, because it seemed like it affected the amount of time I got, because my understanding that I was given half of the minimum. If that's the case, half of my minimum will be 7 years instead of 4, because it was starting off at 14 years, Your Honor. That's the only thing I was just asking about, because it's not right.
Then let's take it up with your new lawyer on the 4th, and we will roadmap this so that there are no surprises, okay?
Yeah, because I've been pleading. I mean, when Sam was on the case, I've been claiming my innocence all the way through this case. I've been claiming my innocence, and I just wanted a fair fight.
Except that you did plead in it, so that was one moment where you didn't proclaim your innocence. So to be clear, there was a big moment there where you were saying, I did this. So we're going to take it up with your new lawyer, sir. So I'll see you back here on the 4th.
I mean,
okay?
I felt like I was backed in the corner. I was under duress.
Mr. Smith, I will see you back here on the 4th, okay?